Good morning, everyone. Welcome to today's hearing. Today we're going to hear further evidence from Mr. Paul Hyet. So would you ask Mr. Hyet to come in, please? Good morning, Mr. Hyet. Yes, Mr. Hyet.
Good morning, Mr. Chairman. Good morning, Mr. Hyet. We were about to look at two pieces of Mr. Soanes's oral evidence yesterday evening, and I'd like now to show those to you and then ask you one or two questions about what he said. First, can we please look at Mr. Soanes's oral evidence at day 7, page 22, line 14. And he says there, rain screen cladding itself is quite straightforward, especially when you've got a concrete substrate. You've got, if it were a new build, and an ideal backing is a concrete background for a rain screen cladding. So the existing building was, in a sense, no different to a new build. It just happened to have a lot of people living in it. That's where the complexity arose. Can I then show you day 10, please? Day 10, page 19 at line 1. And he says there at the top of the page, the lower levels from a fire strategy perspective were much more complex in my view, and I would have been aware of those and focusing on those. Then I would have read the whole report. I would have read the whole report in the context that it was the third version of the report, and that's where it was at the point in time. I wouldn't be going back and analysing it from the perspective of completeness of the brief as you would at the start of a project. Now, the report he's talking about there is the X-over.
I was going to ask. Okay.
Yes,
yep.
For your benefit.
Yep.
Now, my question is, do you think that Studio E underestimated the complexity of the task?
Well, what he says resonates with me in the sense of the rain screen cladding. I can't remember his exact words, but he's implying that it is not too complicated. And the lower part of the building was, from the perspective of an architect. I have some sympathy with that view, but there are different kinds of issue. The lower part of the building involved substantial replanning, and that's, I used the term yesterday, the shifting and manipulation of space. It's spatial planning, and the space has to be arranged both to be efficient and good for the residents, but it's also got to be safe in terms of particularly egress. So there was complexity down there, and I can well understand him pointing to that as being a demanding area. There was no such complexity with the rain screen cladding. It was more a technical issue, but the geometries were complicated. We were looking yesterday at the model and the way the columns protruded beyond the spandrels and the slots between the spandrel and the columns. So there was complex geometry to understand. So I don't think that I would dismiss the complexity of the rain screen cladding work, but it was a different kind of problem.
I see, thank you. In general, would you agree that one aspect of professional competence is understanding the limits on one's own expertise and recognising when third-party expertise is required?
Essential.
And is it your opinion that Studio E failed adequately to do so?
Individuals failed, but the company as a whole also failed in that respect.
Now, in your report, I think you assess Studio E's performance against the RIBA plan of work in use at the time of the refurbishment, or at least the time that the refurbishment began. That's right, I think.
Yes.
Yes. And I think you're also, is this right, judging Studio E against the RIBA Job Book 7th edition 2007 and the Handbook of Practice Management 9th edition of May 2013.
Yeah, I did use both of those, yeah.
Yes, and they, I think, were both in force, just confirmed for me, that at the time of the refurbishment.
Yes.
Yes. And now what about the Arb Code of Conduct? That was clearly in force at the time. Do you accept or agree, in your opinion, that a failure to comply with the Arb Code of Conduct does not of itself constitute unacceptable professional conduct or serious professional incompetence?
Sorry, could you repeat that?
Yes, it's a slightly wide question, but one I've been asked to put to you. Do you agree that a failure to comply with the Arb Code of Conduct does not of itself constitute unacceptable professional conduct or serious professional incompetence?
I don't think it necessarily suggests professional incompetence, but misconduct I would have thought it had to, because the code of conduct is something that we all have to comply with, and failure to comply with that, yeah, I would agree.
Thank you very much. I'm now going to turn to a completely different topic, which is contract terms, and I want to ask you about your view in relation to the terms on which Studio E undertook work for the TMO and then Ryden, and the scope of Studio E's appointment. Now, just to be clear before I embark on these questions, I'm not asking you to interpret the contracts or for any legal opinion from you. What I'm looking for really is your understanding and experience of how a reasonably competent architect would understand these things at the time. Now, do you agree that a large number of large-scale projects similar to the refurbishment project at Grenfell Tower are nowadays, or between 2012 and 2016, procured by way of design and build?
Yes.
And that it would have been unusual for the Grenfell Tower project not to have been procured via that method?
Unfortunately, yes.
You say unfortunately. I'm going to park that as a question that itches to be asked, but we'll come back to it in due course. Are projects procured by way of design and build always tendered at the same RIBA work stage?
No.
What RIBA work stage generally, in your experience, do design and build projects get tendered?
Certainly earlier than this one, in the territory of work stage D.
Is the architect always novated, and I put those words in audible quotation marks, to the successful design and build contractor following the tendering process?
No.
Is it more common than not that the architect is, quotes unquote, novated to the winning contractor?
Well, I've never read any statistics on this, but my experience tells me that, yes, it is more common than not.
Right. Can we look at paragraph 2.2.8, please, of your supplemental report? That's PHYS 602 at page 6. Now, you say here, by way of a quotation from the guidance given in the RIBA job book at page 29, and you set out the quotation there, appointment of an architect as consultant in design and build. And there's a quotation there, and that's the context for this. And then you identify the typical duties. And then you say at 2.2.8, an architect should be well aware not only that it is important to ensure that the duties and scope of services to be provided at any and every stage of his/her involvement under a design and build contract are clearly defined, but also that it is his/her clear professional duty to ensure that this is done and properly recorded. Is it for that reason that you consider that it's no excuse for Studio E to rely on the proposition that during the course of its work for Ryden, there was no signed agreement in place governing its obligations?
Yes, that is correct. That is my view. A qualification is important to ensure duties are clear, whatever the kind of procurement route.
Yes. Are you aware of any challenges which the architectural profession generally faces in agreeing appropriate terms of appointment for these services?
Am I aware of any challenges?
Yes.
From what source?
Well, is it difficult, in practical terms, for architects to agree terms?
Oh, yes. There can be a lot of cut and thrust around appointment terms. Absolutely.
Right. Are there difficulties particularly in ensuring those agreements are agreed and then signed off before any work commences on a project from an architect's perspective?
I've had that experience across the entire course of my professional career.
What about sorry?
Yes,
Sorry.
I have.
Yes. And what sort of, well, is it right that it's also difficult, or there are challenges, when it comes to agreeing variations in the scope or terms of the appointment?
Variations to a standard appointment or variations during the course of the project? That's a question. I'm not quite sure what you mean.
Well, let's take it in a little bit more of a staged approach. What do you think Studio E should have done as the putative, reasonably competent architect if Ryden had not agreed the terms of Studio E's appointment before any further work from Studio E was required, after Ryden had won the tender?
Well, they can down tools, or put it another way, never pick the tools up. That would be a very good starting point. I don't think it's fair of me to say that at the start of every job following an ovation, the contracts are all signed and everything is in place. But there must be clear indication to the architect that there is a defined scope of work, the fees are satisfactory, and that things look good to go. Thereafter, it can take, I think, often a good few weeks into some months for the lawyers to finally tie up the contract on a very, very large job. On a job like this, it might take a good few weeks. It shouldn't endure beyond 3 months. It certainly shouldn't endure through the entire process.
But through the entire process, do you include the construction process?
Of course, yeah.
Yes.
That was going to begin pretty quickly anyway.
Yes. And what about in circumstances where the scope of Studio E's obligations was in practice changing over the course of the works? What would you expect Studio E to do if they couldn't agree specific terms with Ryden?
Well, again, the codes of both, well, certainly the code of the ARB, and I believe from memory the code of the RBA, make it an incumbent duty on the architect to define any changes, and that must be done in writing.
And
Can I just ask you this? Is there any understanding within the construction industry, by which I mean architects and contractors, about the terms on which the architect is working, pending some revision to those terms between the lawyers over the period of weeks that you identified?
I don't think there's any set document. I know of nothing in that form, but usually an exchange of letters would produce some clarity in that area. But it's certainly quite an uncertain period.
I mean, one possibility is that the contractor takes the architect on the same terms as the architect had been working for the original client, unless and until those terms are changed. Is there any understanding to that effect, or something similar?
There's a section in my report that actually explains that, and the RBA have a particular form of appointment for what's called contractor employers, and that would pretty well mirror in fact, the only change is the title. The actual process of work that the architect would be expected to undertake mirrors that of a traditional appointment under D&B.
Right. Yes, thank you very much.
yes, and just to follow up on that, where the architect and the contractor, in this case Studio E and Ryden respectively, hadn't finalised the precise terms of their own engagement between themselves, would it be your opinion that architects would understand that they were being retained on the RIBA form of appointment for contractor employers?
I think that would be, well, certainly the lawyers would have a lot to say about that. I would consider that to be very risky. So if there was anything in there that I was absolutely set against, I would say this is still under negotiation, but this and that paragraphs of your proposed appointment are unacceptable.
Yes.
So I'd set that out pretty clearly.
Yes. It sounds from that answer that your view is that the reasonably prudent architect wouldn't simply not allow their retainer to continue without at least some form of document identifying their obligations after the tender had been awarded. Am I understanding you correctly?
You are, and if I could add to that, once you are in contract, it's actually pretty difficult in this country to stop. I have experience of American contracts. Downing tools, a term I used a few minutes ago, is relatively easy in America. It's not here. So once you start, you have to be in a position to resolve problems like that as you go along, or go through quite a complicated process of suspending and terminating work.
So you are of the view, I take it, that it would have been reasonable for Studio E to refuse to commence any work for Ryden until agreement as to the extent and nature of Studio E's obligations had been agreed.
Yes, to be absolutely clear, I wouldn't hold back until the contract's absolutely signed, but I'd want the principles sorted.
Right. And unreasonable of Studio E not to have done that. Is that...
I would use the word unwise.
Yes, we've had that before. I'm going to press you a little bit. Unwise, but is it unwise to the extent of imprudent, unreasonably imprudent, by the objective standards we are examining?
I think it's putting the project at risk as well as the firm.
Right. And do I take it from that a reasonably competent architect would do nothing to put the project at risk?
Yeah, that's correct.
Yes, thank you. Just a question from your perspective about Artelia as the employer's agent. From the perspective of the reasonably competent architect, would that person expect Artelia as the employer's agent to do something in circumstances where the employer's agent can see that no terms, or at least principles, had been agreed as between the contractor and the architect?
Yes, absolutely.
And what would you expect?
Well, as employer's agent, Artelia were responsible for a substantial part of the administration on the part of the client. And I can't think of anything more important in that administration process at the start than making sure the contract's in place.
Yes, thank you. Can I then turn on just to ask you a question about Mr. Crawford's evidence, and I'll summarise it. He said, and indeed Mr. Lawrence of Ryden, Simon Lawrence of Ryden, have also said that Ryden tended not to use architects so much. Indeed, and I don't need to go to it, I think, with you, Mr. Crawford said in his oral evidence, and that's at day 9, page 103, line 18 of the transcript. We don't need to turn it up. But he envisaged Studio E's role as being more responsive. Now, about that issue, on the assumption that, in fact, such conversations between Mr. Crawford and Mr. Soanes did take place, is it your opinion that Studio E ought to have produced and agreed with Ryden a clear record of exactly what was expected of Studio E by Ryden?
Yes.
Yes. And it would be normal practice, I think you're saying, for an architect to do that as early as possible rather than to wait to the end of the project?
Yes.
Would a reasonably competent architect study carefully the terms of any formal agreement that it was entering at any stage to ensure that it wasn't taking on any legal responsibility for things over which it had no control or which it had not done itself?
Right through the scale of projects I've been involved with, and you mentioned Optus yesterday, I've personally either been involved myself or somebody else in the firm has been involved. I can't imagine passing responsibility for negotiating a contract to parties outside the firm, even appointed lawyers. The architect has to remain involved.
Yes, and involved, and I'll just ask the question again, would a reasonably competent architect actually sit down and study the terms of the contract to make sure that he or she or it, the firm, wasn't taking on any responsibility for things over which it had no control or which it hadn't done? On
the contract I just referred to, which is the most recent large one I've negotiated, every paragraph through an enormous document over a number of individual days spread across weeks was what each of the 3 firms of architects appointed did, and they did it together.
Yes, thank you.
And I was the one who did it for
That's your experience, and
Yes.
I completely accept that as an answer, but I'm just after what your view of the reasonably competent architect, the objectively reasonably competent architect would do. Would they sit down and study the terms of the formal contract to make sure that they were not taking on legal responsibility for things over which they had no control or things which they hadn't themselves done?
I can conceive circumstances where the terms might be summarised, but the architect has to know what they have undertaken.
Yeah, thank you. Can I then turn to a different topic still, which is design responsibility? Can we look first at your supplemental report, please, at PHYS 602, page 30. And I'd like to look with you, please, Mr. Hyet, at paragraphs 2.3.20 and 21. At 2.3.20, you say, Studio E also seems to be suggesting, for example, at opening statement, paragraph 13.6, that its duty to comment under its post-novation obligations to Ryden in relation to Harley drawings was restricted to matters of, quotes, architectural intent, close quotes, by which I understand it means matters of aesthetics and appearance only, and did not extend to technical or compliance-related matters. I have seen no documentation to support this view, and such a restriction of duties is not consistent with my understanding of an architect's normal duties when receiving and reviewing specialist subcontractors' information. In this respect, I quote variously from the Schedule of Architectural Services of the Ryden Studio E Deed of Appointment, and you give the reference, which contradicts this view entirely, and I'll quote, seek to ensure that all designs comply with the relevant statutory requirements, including scheme development standards, item 8 at page 8, examine subcontractors and suppliers' drawings and details, interface details, with particular reference to tolerances and dimensional coordination, finish, durability, appearance, and performance criteria, and report to the contractor, item 27 at page 9. Now, I've shown you that in full. Is it your opinion that to the extent that Studio E appeared to consider that their duty was limited to commentary in respect of architectural intent, that they were wrong about that?
Yes.
Yes. Would any reasonably competent architect think that they were right about that?
I don't think so.
Now, can we look specifically at the 2 items you refer to there within the deed of appointment? You've given the reference within the text of 2.3.21, but we can look at it. It's RYD 3094228 at page 9, and item 8, which is the first of the 2 items, as you say, says seek to ensure that all designs comply with relevant statutory requirements, including scheme development standards. And then if we look at item 27 on page 10, please, the next page over, it says examine subcontractors and suppliers' drawings and details, etc. And I've read that already aloud into the record. My question about these 2 items is this. Were these services typical obligations as between an architect and a design and build contractor in the UK construction industry and the architect's profession respectively between July 2014 and February 2016?
Well, again, I haven't surveyed I haven't got any evidence of that, but I certainly don't think they're unusual.
Right. Now, at paragraph 2.3.21, which we've just looked at, you say, just go back to that. You say, such a restriction of duties is not consistent with my understanding of an architect's normal duties. And then you set those out. And you say at the end of that paragraph before the quotation that the deed of appointment contradicts this view entirely. You see that?
Sorry, I lost you at the first quote. Is that a quote from the text here or what I just said?
Yes, the text of what you've said. If you look at paragraph 2.3.21,
yes,
you say in the second line that the restriction of duties is not consistent with your understanding of an architect's normal duties.
Right.
And then you say, just at the end of that paragraph, that the deed of appointment contradicts this view entirely. You see that?
Yes.
Is it therefore your opinion that these services listed at items 8 and 27 that I've shown you are not consistent with a review merely for architectural intent? In other words, they go further than that.
Oh, they certainly. Yes, by architectural intent, we're talking about aesthetic appearance. Of course, they go substantially further than that.
Yes. And what is the difference between a review for architectural intent on the one hand and what is involved in the performance of these obligations at items 8 and 27 on the other?
Again, I don't know the definition, but I think a review for architectural intent would be interpreted by most architects to mean that in terms of appearance, it would be the same or very similar. And I think it would relate more to elevations and finishes inside the building as opposed to planning and organisation.
Yes, or putting it more bluntly, does architectural intent, as you understand it, encompass or include seeking to ensure that all designs comply with relevant statutory requirements, including scheme development standards?
On the interpretation I've just applied, no. No, it wouldn't.
No. And what about the next one, examining subcontractors and
No.
No, thank you. Do you consider that the reasonably competent architect ought to ensure that there's consistency between the drawings and the specifications as developed and issued out to tender and the work undertaken by the specialist cladding subcontractor developing the design of the architect?
Well, if retained, novated, appointed, yes.
Yes. And would that work go beyond review for, quotes, architectural intent, close
Most certainly, most certainly.
Can we then look on in your report, the main report, which is PHYR 5027 at page 54. That's PHYR 5027 at page 54. And I'd like to look with you, please, at paragraph 2.10.27, where you say a fifth important issue is that of prefabrication and off-site fabrication. And 5 lines down, or 6 lines down, in that paragraph, you see that there's a sentence which starts, metal specialised cladding panels require the preparation of fabrication drawings by the subcontractor or its supplier, and these in turn require inspection and effective sign-off by the architect and or other consultants. What do you mean there specifically by fabrication drawings in respect of the metal specialised cladding panels?
Well, those would be drawings prepared by the subcontractor. That's the first point. But it's very important that they're checked and checked carefully. And one of the major reasons for that is that metal is such an unyielding, unforgiving kind of material. With timber, you can have tradespeople, skilled craftsmen on site who can work it, likewise with bricks. But once you get down to preformed metal panels and flashings and all the other paraphernalia that goes together with a system like that, it has to be made away from the site. That's almost universally true, I think. And so getting those things right so that they're delivered right in terms of the programming of the construction is essential. Otherwise, great delays can arise very quickly with big knock-on effects.
Other than delays, what are the other risks or any other risks that you can identify?
Well, the failure of the product to look as it should when it arrives, the failure of the product to fit, the failure as it should when it arrives, which might be a problem of assembly, but the failure to fit might lead to breaches of code. So there's another example.
When the architect, that is the reasonably prudent architect, is signing off these fabrication drawings, can you give us an idea of the sort of detail that they'd be checking in order to give what you call the effective sign-off?
there'd be an ordered process, and marking up the drawings is very, very common as they go. Notepad to the side, but I think that it would be important for an architect to check and read the entirety of the drawing. That's all the spatial arrangements, all the drawn lines, but also all the words and all the dimensions. I'm not necessarily suggesting that every single dimension has to be ultimately ratified, but the principal dimensions have to be sort understood and signed off by the architect, and any specification notes, that all needs to be read and understood.
Right. Now, you've referred to the fabrication drawings, I think, of the specialist subcontractor. That's Harley in this case, is it?
Yes.
Yes. Do you consider that Studio E were under any obligation to examine or sign off CEP's fabrication drawings, so far as they ever saw them?
Well, they're a subcontractor of Harley.
Yes.
So as far as the architect's concerned, I think as far as those drawings, well, firstly, Harley have a duty to pass through sufficient material in the form of drawings and specification information for the architect to be satisfied that the work has been properly understood and is being properly developed.
I see. So
if CP's drawings are amongst that, then they'll have to check them, yes.
Yes, I see. But essentially, I think you're saying that it would come with the Harley work.
Yes.
Yes. Going back to the question of architectural intent for a moment, is it, in your experience, common practice within the architect's profession, for the architect to limit his obligation or her obligation to review the drawings and details of the specialist subcontractor only to review for adherence with architectural intent?
I think are you referring there to the stamp that was used on the drawings?
The stamp or the idea behind the stamp. Let me ask the question again. Is it common in the profession, or was it common in the profession at the time, for the architect to limit their obligation to a review of the drawings and details for architectural intent?
Yes, but I think the term architectural intent there means something slightly different. That is, do you want me to explain what I'm...
Yes, please.
Yeah, that would be that the design work as shown on the drawings and incorporated into the specification as issued by the architect, and that's not just its appearance, that's the whole lot, has been properly understood, interpreted and applied to the subcontractor's drawings.
Right. So architectural intent isn't simply aesthetic. I think that's what you're telling us.
In that context, no.
I see. But the definition, I think, of architectural intent that you've just given us is a very broad one, which encompasses a wide range of obligations, including drawings and incorporation into the specification as issued. What about materials?
Well, as far as they're described on the drawings, and any specification that has been issued, yes, they'd be included.
Right. So do you understand the expression architectural intent to be absolutely everything which the architect intends through the drawings and the specification?
In the context of that checking, yes.
I see. So is that how you understood the stamp? Maybe we were getting ahead of ourselves a little bit in the questions, but let's deal with it now. Is that how you, as the expert architect, would have understood the idea, architectural intent, or the stamp that used the expression?
Yes, there'll be more detail on that question, I'm sure, but yes, and I cannot imagine that an architect would see drawings and specification passing through from the subcontractor that departed from the intent of the architect as expressed in his own work, his or her own work, without raising questions or alarm bells.
Right. If the use of the expression architectural intent was intended to be a limiting one, limited perhaps simply to matters of aesthetics, would you expect that limitation to be recorded clearly in the formal appointment or a formal appointment document between the architect and the design and build contractor.
Without any doubt whatsoever.
Can we then look at the transcript for day 38, please? Before I ask you this question, I'll have the page up. It's page 8, and we're going to go to line 3. Before I ask you that, just arising out of the last answer, would you expect the definition of architectural intent, therefore, to cover the things included in items 8 and 27 of the deed of appointment that we looked at earlier? So compliance with statutory requirements, etc.
Yes. I was trying to remember exactly what was in those, but yes.
Yes. Fair enough. 8 is statutory requirements, and 27 was subcontractors and suppliers' drawings and details with particular references to tolerances, drawing, dimensional coordination, finish, durability, performance, etc. That's what they said. So you would expect those matters to be covered, would you, by the expression architectural intent?
Architectural intent is what is shown on the architect's drawings. The specialist subcontractor will be developing fabrication information and more detailed information. I'm talking about screw sizes, washers, right down to very, very detailed component selection or manufacture. I don't want to go beyond what's on the architect's drawings and specifications. I accept that there would be another layer that the subcontractor may well be involved in. That layer may be generally described in engineers or architect specifications, may not at all. So I would restrict it to architectural intent being the proper application of what has been shown on the architect's drawings and specifications.
What about specifically item 8, which is checking for statutory compliance? Would your understanding of the expression architectural intent encompass the adherence to the subcontractor's drawings with statutory requirements?
Well, I think there's another clause in that riding appointment that deals with that anyway, if I remember rightly. But the architect's work should comply with statutory compliance anyway, so it would follow, I think.
Right, I see. So can we leave it this way, that whatever architectural intent might or might not include, it would always include ensuring that the drawings that came up from the specialist cladding subcontractor to the architect for review or approval complied with the statutory obligations?
Yes, that is correct.
Yes. Can we then look at Mr. Lamb's evidence, day 38, page 8, line 3? He was asked the question by Ms. Grange, who, in your view, had ultimate responsibility for checking and approving the drawings you were producing? Who did the buck stop with? And you can see the answer at line 6, the architect. And he was then asked at line 7, and that would be consistent with what we've just looked at and your understanding of the process, question mark, to which he said at line 9, that's correct, yes. Do you agree with Mr. Lamb on this point?
Yes, but with the proviso that it always depends on the appointment terms that the architect is engaged by.
Yeah, yes, and having seen the
yes, in this
terms
case,
in this particular instance, what do you think?
Yes, I'm sorry, I anticipated your question, yes.
Yes. Might the answer depend on the particular issue in question? For example, the dividing line as to the responsibility for a drawing might be different depending on what the item in question is. Is that a fair qualification?
Yes.
Yes. So might it be the case, and tell me if this is wrong, that on matters of engineering, for example, fixing cleats or connecting bolt sizes, or the viability of a fabricating component, might well be the responsibility of Harley as opposed to that of the architect?
Yes, and I think I'd alluded to that earlier on.
So there might be a drawing, a dividing line where you draw the distinction between the two.
Yes, and if I wasn't clear about that, I'm sorry, because a few questions ago, I think I made that point.
You did. Okay, thank you. That's clarified that. When a drawing is stamped approved for construction by the cladding subcontractor, what, in your opinion, does that mean to the reasonably competent architect?
Exactly what it says. I would probably extend that to approved for fabrication, because they've actually stamped it and you can't construct it if it hasn't been fabricated. So I would say that that is a drawing that's been stamped as compliant with all the requirements and good to go.
And would I be right to take it from that answer that you think that the drawing stamped approved for construction would be a complete and accurate representation of everything that would be required in respect of the particular component or detail which is shown in the drawing?
Yes, and there's some questions, no doubt, that will follow about whether those drawings should have been so stamped at those various stages, but I'm sure we'll come on to that.
Now, would a competent architect ever look at a drawing stamped approved for construction and reasonably think that it was effectively incomplete or in progress as more information came through?
No, it would be a strange thing to do if the drawing's not complete. It's not complete. If the architect's checking work hasn't been carried out, it hasn't been carried out. So I wouldn't be persuaded by a stamp. I wouldn't be persuaded that the stamp told me that I haven't got the checking job to do.
No, I mean, from what you're saying, it tells us that it's not your experience of industry practice that a drawing that is stamped approved for construction was essentially telling the architect that the drawing was incomplete or work in progress.
Well, the architect has the duties that the architect has under the appointment, full stop.
And I think you're telling us that an architect would read approved for construction as a final and complete depiction of what was in the drawing. Nothing more to do.
I don't think, I'm saying that the architect has duties to carry out. If that drawing's arriving for the first time and the architect hasn't checked it in accordance with his duties, her duties under the contract, then that checking process needs to take place. If that drawing's got a approved for construction stamp on it, I wouldn't be persuaded by that stamp. I wouldn't accept that that tells me I've no longer got the checking job to do.
I understand that. But would he read the words approved for construction as a representation by the subcontractor that the drawing was in some way incomplete?
I can't understand what they meant by that stamp.
Right. Can we go to paragraph 2.3.2 of your supplemental report at PHYS 602, page 25, please? And you say in paragraph 2.3.2, it is not the case that because a contractor or specialist subcontractor such as Harley had responsibility to complete detailed design, as referred to under paragraph 12.14 of Studio E's opening statement, that this in any way relieved Studio E from its duty to carry out and complete its own design work in relation to the external wall in accordance with its obligations under work stages E and F1. I deal with this point more extensively below. What do you say in respect of Studio E's work at work stages F2 and following?
Well, they didn't have a duty to carry out F2 after the novation, because although their original appointment to the TMO included for all work stages, I think, through to L, and therefore at that point in time it was anticipated at the very least that they would see all of that work through. That appointment was suspended. Now, they could have, as the chair has just intimated, they could have been transferred over or novated to Ryden on the basis that they would carry out exactly the same duties, but for Ryden rather than the TMO. But those, the form of appointment was changed, and the Ryden appointment was a completely different document. However, on examining that document, it demands is probably the wrong word, it requires work that I would describe as being included in a normal interpretation of F2. So going to the Ryden appointment, they were required to continue work on detailed design.
Would it be normal for an architect to consider that where a specialist subcontractor has assumed design responsibilities to the design and build main contractor, the architect is thereby relieved from its own obligation to fulfill the duties that it's contracted with the client, his original client, to undertake, at least where the retainer direct by the client has not been formally terminated?
I think we're going to get into considerably complex territory here in interpreting the word design. Could you ask the question again?
Yes. All right. Well, let me try it without the word design in it then. Would it be normal for an architect to think that where a specialist subcontractor, such as Harley in this case, has assumed responsibilities to the design and build contractor, which would include design in some respects, the architect is thereby relieved from its own obligation to fulfill those obligations that it has contracted with his original client to undertake?
The obligations, my understanding as an architect, are the obligations that I had would have had to the client originally imposed on me a duty to carry out that work and to complete it. And in circumstances where I hadn't completed, I need to make it jolly clear that I haven't. So the subsequent appointment of a subcontractor to further develop that work doesn't release me from my duties to make sure that that work in its original form was correct.
Yes. So
I think we're onto code here. I'm anticipating that's the background, but I shouldn't anticipate.
When you say we're on to code, can you just explain what you mean?
I'm talking there about the architect's obligations to make sure that the design work done in the documentation at employer's requirement stage complied with the building regulations and ADB2.
I see what you mean, yes. So do I take it from that answer that the architect remains obliged to undertake and fulfill the duties that it contracted to fulfill under the original appointment from his original client, in this case the TMO, notwithstanding the appointment of a main contractor and his subcontractor?
I think it's a legal point, I'm sure, but I think the responsibilities for the work that was done for the TMO remained live. That would be my understanding of it. Having accepted the novation, signed or not, from Ryden, I would understand that I had the same responsibilities of those that I've just described, repeated in terms of my duty to Ryden and through Ryden, because Ryden had assumed design responsibility, but they had then produced a back-to-back contract. So I carried the duty twice.
Yes. Thank you. You're quite right that I put it to you as a legal point, but actually what I was after was your understanding as a professional, and you've given me that, so I'm grateful for that. And would it be your understanding as an architect that if there was any, if the architect thought that his or the practice's obligations were in some sense being restricted or whittled down as a result of the design and build main contractor and its subcontractor coming in, then the architect ought to seek a variation to the responsibilities that he'd undertaken to the client?
An absolute clarification. And if I may add here, we're dealing with very important issues, principally safety, and I'm not restricting that to the issues of fire. I'm talking about a host of other issues, panels falling off buildings, all sorts of things. So it's very, very important to make sure that the work is being properly carried out. And there should be no room for ambiguity about who is carrying these duties. And if the architect feels that his terms of appointment aren't allowing him to do the job properly, then he should make it absolutely clear.
Thank you very much. Can I just close this point off then? And I suspect that you've given us the answers already, but I just want to close it off by reference to your report. Can we turn the page to page 26 in this report, please, and look at paragraph 2.3.6? You say there, whilst this is a legal matter upon which the inquiry will decide, it is my opinion that Studio E are correct in asserting that under design and build procurement design responsibility for the work hitherto carried out for KCTMO as incorporated into the employer's requirements documentation did indeed pass to the contractor. However, Studio E is quite wrong in its apparent belief that with the assumption of design responsibility on the part of Ryden as design and build contractor, Studio E's design responsibility respectively was and would be absolved in terms of work done hitherto under its appointment to KCTMO and under novation to Ryden. Now, you say Studio E is quite wrong there. Could you just explain why Studio E is quite wrong, as you say?
Well, I believe that the Ryden documentation makes it clear that Studio E is responsible for its design work anyway. I think I've referred to that somewhere else in this part of the report. But let me read it again, please.
Yes, of course.
No, Studio E have accepted a novation. The design and build contractor has principal immediate responsibility to the client under the terms that they entered into for past work. So they assumed responsibility for work done by the design team and architect pre-novation, and they accepted it for all work that would be done post-novation. That is what the Ryden document essentially laid out. The Ryden document, that was with the client. The Ryden document also made it clear that the architect was carrying responsibility for work, and it's listed 1 to 5 drawings. There's a host of work actually described that the Studio E would be responsible to Ryden for. So I don't think that they can suddenly they can introduce the idea that their responsibilities fall away in this fashion.
Mr. Millett, I think Mr. Hyet would be the first to accept that the nature of the legal obligations arising from the original appointment, the novation and so on, are essentially matters of law, aren't they?
Yes.
On which he probably can't help us.
No, that's right, which is why I think he prefaces this paragraph with the words, whilst this is a legal matter. And I'm just seeking to, I think I've got the answer, but I think simply seeking to close this off by relating the Studio E as quite wrong view with the previous answers he's given.
That's his view about whether Studio E's view of the contractual relationships is correct or not, but
well,
not sure his view on that is one which we really need to pursue, is it?
Very well, we'll leave that where it lies. Can I then turn to another topic, which is compliance and specification of materials generally? I'm going to ask you some questions about the regulatory regime at the time of the Grenfell Tower refurbishment and the specification of materials in general terms, and then we're going to look more specifically about the actual materials, so the ACM and the insulation, and then the cavity barriers. Now, can I ask you to go, please, to your report at PHYR 5027, at page 46. And I want to go to paragraph 2.9.2. And there's a long paragraph. I'm not going to read it all out to you, but you set out the relevant quotations from the requirements of B3 and B4 of the building regulations. But before you do that, you say this. In relation to the issue of fire, the requirements and intentions of the building regulations 2010, as at the time of construction of the 2012 to 16 works, were, in my opinion, absolutely clear. The fire should have been impeded from breaking out of the compartment, quotes unquotes, in which it started, and in circumstances where any breakout occurred, the spread of fire should thereafter have been consistently impeded. The word inhibited is typically used in this context. And then you quote. And then you go on at paragraph 2.9.4 at the foot of that very same page to say, it should therefore be clear to all whose work is required to comply with the building regulations that the regulations are essentially descriptive of intent as opposed to being prescriptive of method. This point is fundamental, the reason being, in brief, to permit innovation in design and construction as opposed to placing designers and constructors in a metaphorical straitjacket. But if you go over the page to page 47, at paragraph 2.9.8, you say, despite their brevity, the building regulations make absolute demands and are inclusive in scope and ordered with clarity. And then at 2.9.6, just a little bit above that, you say in the second line that no competent architect could ever credibly claim to be unaware of the importance of designing responsibly in relation to fire, both in terms of spatial arrangements with respect to facilitating rapid escape where necessary for occupants through designated protected routes, and in terms of materials and methods of construction. Now, I put a lot of that to you just to bring it all together in one place. Do you agree that a reasonably competent architect responsible for the initial design of the overcladding system at Grenfell Tower ought to have been aware of the requirements of B3 and B4 and also B2 of the building regulations?
Yes.
And is it your opinion that the reasonably competent architect would understand that that meant that, first, the integrity of the structure must be preserved for a reasonable period, pursuant to B3 subparagraph 1?
Yes.
And also that the spread of fire and smoke must be delayed for a reasonable period, both internally and externally, pursuant to B2 subpara 1, B3 subparas 3 and 4,
Yes.
B4 1, yes. Is it your opinion, as a result, that that would require the reasonably competent architect to consider the precise build-up of the external wall structure and its elements in order to understand whether it, as a system, could resist the spread of fire for a reasonable period?
Yes.
Now, can we go to your supplemental report, please, at PHYS 60s24, and go to page 60. And I want to show you 2.7, section 2.7, and you entitle that as theme F, 4 routes to compliance, Studio E opening statement, paragraph 9 et sec. And you start by saying that you agree with Studio E's opening statement that there are 4 possible routes to demonstrating compliance of a design proposal for a range screen facade in terms of the entire wall construction of which it forms a part with the requirements of the building regulations. And then you say, as I've already made clear from the evidence which I've seen, there is no indication that any of the alternative avenues to compliance were either explored or pursued by Studio E or the design team. Now, before June 2017, and specifically, I'm really interested in the period 2012 to 2016, were you aware of there being a number of different routes to compliance with functional requirement B4 of the building regulations?
No.
You weren't?
No.
So just to be clear, you weren't aware that there was a linear route or the 8414 route or
The question was about 4. I knew that one had to either design to comply with ADB, with the approved document, or one could find alternative methods and take guidance on them. But I wasn't aware of the specific nature of each of those different routes.
Would you expect a reasonably competent architect either to have a level of familiarity when confronted with an overcladding structure or to obtain such familiarity during their initial research on being appointed to such a project?
I'd expect them to obtain, well, I wouldn't expect them necessarily to have that knowledge, but I'd expect them to obtain it as they began to prepare their work.
Very briefly, I think you agreed that approved document B requires at section B4, under paragraph 12.5, or section 12.5, that external walls should either meet the guidance given in section B4, paragraphs 12.6 to 12.9, on the one hand,
Yes.
as one route, or alternatively meet the performance criteria set out in BR 135 using data from a full-scale test under BS 8414. Yes. And do I take it that as at 2012 to 2016, did you know of the existence of BR 135 or heard reference to full-scale BS 8414?
I knew about full-scale testing.
Yes.
I wouldn't have been able to rehearse the exact standards. I would have had to either take advice or look at the documentation.
Yes.
But I knew of the process.
Yes. And again, are these things which you would expect a reasonably competent architect to become familiar with at the start of the project?
Yes, the way we work is to develop a design work with an array of issues that we're going to need to investigate and understand as the work proceeds. And so that would be a routine part of the work.
Right. Yes, thank you. Now, can I show you Technical Guidance Note 18 issued by the BCA in June 2014 as issue 0, which is at CEL 401284, please?
No.
Now, I think I could probably take this quite quickly because if you go to page 2, and this is a document that we've seen in the record a number of times now with some of the factual witnesses. If you go to page 2, you can see at the top of the page, it says that where a building exceeds 18 metres in height, the BCA recommends 3 options for showing compliance with paragraph 12.7 of ADB2. And then there are 3 options there set out. Option 1 is the use of materials of limited combustibility. Option 2, and I'm summarising it, is a full-scale test to satisfy the criteria in BR 135. And then option 3 is a desktop study report from a suitable independent UCAS-accredited testing body, for example, the BRE. Now, you can see that those are the 3 options there. Were you familiar with this document when it was published in June 2014?
No.
And what about its successor, issue 1, issued a year later in June 2015?
No.
Were you aware that in June 2015 a 4th option was presented, namely a preparation of a holistic fire engineering report as another route to compliance?
Not at the time. I've become aware through researching for this report, but not at the time.
Right. But again, looking at those options, whether it's 3 options as at June 2014 or 4 options as at June 2015, would you expect a reasonably competent architect to become familiar with these when presented with an overcladding project?
I would expect an architect to start by looking at ADB2 and deciding whether there was any reason to go outside ADB2.
Yeah. Do you, I could put this to you, ADB2 in fact also includes, although not within section 12 I think, the what became the 4th option in June 2015, namely the holistic fire engineering approach. It was already in the building regulations. So it wasn't a new thing in June 2015.
Yes, I've learned that during the course of this research.
Right. Can we look at paragraph 4.4.8, please, of your report at PHYR 5029?
May I make one further point?
Yes.
The option here that talks about a full-scale test, that kind of work is pretty complicated to set up. It's time-consuming and it's expensive. I wouldn't expect a project like this to normally introduce that as an option. An architect wouldn't routinely say, oh, we'd like to set up a full-scale test. Such testing has to be very exact. The entire wall has to be assembled, etc., etc. It would be very strange to go off down that route unless there was an imperative for doing so. The normal route would be to take the ADB2.
By which you mean linear, I think people have called it linear route.
Correct.
And just to be clear for everyone watching, does that mean simply the selection of materials which were either non-combustible or genuinely of limited combustibility?
Correct.
And so far as the exterior wall is concerned, genuinely compliant with the fire classifications?
Correct.
Can I ask you then to look with me at where we were going, which is your report at PHYR 5029, please, at page 104. And I'd like to go to paragraph 4.4.78 there in the middle of the page. You say, I wouldn't expect an architect, a specialist cladding contractor or a rain screen contractor to be aware of the advices and circulars as issued by the BCA, but I would certainly expect a building control department, either through direct membership of the BCA or indirectly through their membership of the LABC, to be properly informed of such advice. Now, I show you that. Can I also show you your report at another part? PHYR 5028, page 4, please. And paragraph 3.1.8 there, you say in the middle of the page, I thus show and describe through a combination of diagrams and specification notes an outline of some of the key features of such an overcladding scheme. These would form the basis for routine discussions with manufacturers, suppliers, and the building regulations officers in preparing a scheme that would satisfy the requirements of the building regulations and be compliant with the guidance in the approved documents. It is important to note that this kind of work cannot be fully developed without such discussions which, as I will show in section 4, were not conducted with appropriate effect. Now, just to be clear, by building regulations officers, do you mean building control?
Yes.
BCOs, building control officers?
Yes.
Yes. Is it your opinion that an architect, a reasonably prudent architect, would normally involve the building control body in preparing their initial scheme design?
This is pre-tender, pre-employer's requirements. Yes. Depends on the complexity and size of the job, of course, and how familiar the architect is with that particular type of work. But in the circumstances here, pretty big and complex job, and Studio E's experience in this territory, I would certainly expect them to engage with the building regulations department.
Can we be a bit more precise at what stage you would expect them to do that? Was it before they put pen to paper or after they developed their scheme design and got to employees' requirements?
Building control departments are terribly busy and getting access to them can be difficult at times. So the architect, I think, has a professional duty to get him or herself sorted out and carry out a code review, understand the basic issues that are going to have to be dealt with, develop the in-principle proposition, then set up a meeting or meetings in order to establish that there's general acceptance to that. And with that meeting, there may be some specific questions as well.
Right. So do I take it from that answer that a reasonably competent architect would use building control as a check to make sure that the design that the architect had prepared thus far was compliant, or rather was compliant with the building regulations?
I don't like the word check there.
No, what would you? I agree with you. It wasn't perhaps a well.
Sorry, I meant no disrespect by that, but
no, but I want to know what your opinion is. What would be the purpose of an architect going to building control with a drawing?
With design build work in particular, where the building regulations application is usually, I think, by far the majority of cases, issued by the builder after the builder has been appointed, it's very important to ensure that the principles of the design have been properly sorted. And many builders would wish to see some kind of comfort that dialogue had taken place and principles had been agreed. Sometimes local authority control department are willing to issue what's called a letter of comfort. Other times, the architect will rely on notes that they took at those meetings. But I think being comfortable that the principles are correct and have been properly interpreted, you used the word checking. I don't like checking because it suggests transferring of responsibility. But being comfortable, being assured, as far as reasonably possible, that I think is good.
Just to get back to...
Sorry, there may be some issues, I beg your pardon, there may be issues that require interpretation. There are options. You can read the guidance. It's not the regulations. The regulations are clear, but you can read the guidance and interpret it. It might mean this or that. I'll use an example, a cavity barrier in a variety of positions around the column. I'd just like to discuss that. And those sort of issues might be issues that one seeks guidance from the building control department on.
Right. Do I take it from that? And forgive me if this is this is reaching into the dark a little bit. But do I take it from that the approved documents, such as approved document B, are so susceptible of different views about what they mean that it would be normal for an architect to consult a building control officer, as it were, an expert on how to interpret the building regulations?
Well, so susceptible suggests a general weakness. I think my experience is that they provide a pretty good guide, but nevertheless there is still areas that one might wish to double check, and there may be one of the... I was going to use the word safe. I don't like the word safe, but an example would be the cavity barrier over the top of the window. The windows on this building, the top frame of the window actually abutted the concrete soffit of the concrete slab. Some windows are set 300 millimeters down from a concrete slab. There is a requirement that there is a cavity barrier to the top of the window. There is also a requirement that there is a cavity barrier to at the point of the compartmentation. Those two, that would suggest that it's two cavity barriers. It may be that the design could double up, for want of a better term, could use one single arrangement to meet both of those requirements. That might be an issue for discussion with the fire consultant and with the building regulations department.
I see. In the process of these discussions, would you expect that an architect might become aware of Building Control Alliance guidance, such as Technical Guidance Note 18?
Might do, but I don't think there's any... I have no sense that an architect should discover that.
Ms. Menzies, in her report, and I'll just give the reference, it's paragraph 172 at BMER 604, page 45, is of the opinion that a local authority building control is not required to adhere to the guidance issued by bodies such as the LABC or the BCA, and she confirmed that view in her oral evidence at day 29, page 78, line 5. That's her opinion. You say in your report here that you would have expected a building control department to have been informed of the BCA advice. Is that right? Does her, well, let me put it differently, does her opinion that she's expressed both in her report and orally change your view in any way?
No, I think I'm not a building control officer. but I think a building control department should be aware of such information. I don't think they necessarily have to be directed by that information. It would depend on the issue, but I think that they should be aware of it. It's very important to stay up to date as far as possible. Organisations like the BCA are mopping up, for want of a better term, all sorts of information from a variety of sources. It's like the RIBA for us, and feeding through information to those in the field who are working, and it's very useful to get that kind of guidance. Why would one not want it?
Yes, thank you very much. Mr. Chairman, we are sort of mid-topic, really, and there's no reasonable prospect of finishing it before the coffee break.
Well, shall we give in then and have a break now?
I think it would be sensible. Thank you.
All right, thank you. Mr. Hyet, we'll again have a short break in the morning now. We'll come back at 25 to 12, please. And again, while you're out of the room, please don't talk to anyone about your evidence.
I will not.
All right, thank you very much. I'd like to hear the usher. Thank you. (25 to 12), please. Thank you. Yes, would you ask Mr. Hyet to come back in, please? Right, Mr. Hyet, ready
Yes,
to
I'm-
continue? Yes, Mr.
Mr. Hyet, I'm afraid we were mid-topic when we broke, but we can get back to it. Can we look at the transcript for day 9, please, at page 9? I want to show you something that Mr. Crawford said in his evidence to the inquiry. Day 9, page 9, line 8. And he says here, I would say the way that as an architect you use building regulations is much in the same way you use an encyclopedia, i.e. you don't read it from front to back, you look at the documents as they become relevant. So, for example, 2014, I had done dozens of projects, so in each project you would look at the regulations that were relevant to that, pertinent to that project, or pertinent to what you were doing on that project. So Part B I was familiar with because I'd worked on projects where clearly that was a large part of the building, and the fire strategy is fundamental in any project. Do you agree, first of all, that a fire strategy is fundamental in any project?
Yes.
Yes. Do you think that a reasonably competent architect would be familiar or become familiar, in broad terms, on a project with the B3 and B4 requirements of the building regulations?
On a building project of this type, yes, of course.
Yes. And do you agree with Mr. Crawford's characterisation of the use of the building regulations in the same way as one might use an encyclopedia?
I'd like to qualify my answer in that respect. Yes, word encyclopedia is an interesting one, but yes, it's a reference document that you use and you work with as you develop your design. However, I think it's very good at some point in an architect's career for them to have actually been completely through the building regulations, and in this case, since they developed, I didn't have them when I trained, but the approved documents, so that one has got a general familiarity with the whole lot. That wouldn't lead to you being competent to remember it all. You'd have to work the document thereafter in that way described as a sort of encyclopedia. But you need a general understanding of what's there and what you're expected to deal with.
Now, just following up on that, you say you think it's a very good, at some point in an architect's career, for them to have actually been completely through the building regulations. In an architect's training as it stood in the years up to and perhaps including 2012, 2013, 2014, particularly, what point in an architect's career would the need or opportunity to go through the building regulations as a single corpus arise?
In preparation for Part 3 examination.
Right. Is that the only one?
To go through the whole lot in that way, yes. And that the way I did it was it took the form of a structured course as part of Part 3, and we were introduced to various aspects.
Yes.
So that's the longer answer. The short one is that would be the point.
Right, I see that. And if you hadn't done Part 3, then you'd never get the holistic overview of the entirety of the approved documents.
It's certainly very much less likely. It's a very convenient way of doing it.
Yes, indeed. Can I then ask you to go to PHYS 505, please, your supplemental report at page 19. PHYS 505 at page 19. And let's look together, please, at paragraph 3.3.4.3. And you're there dealing with submissions made by Exova. I just want to look at B. You say, I agree, B, that the extent to which a specialist fire consultant input is needed in such situations would depend on the route to compliance that is adopted. And then you go on in the next paragraph, 3.3.4.4, to say the corollary of this is also true. That is, that a specialist fire engineer should not normally be required to assist an architect in interpreting and applying the guidance of ADB 2 with respect to specifying the materials within and designing the arrangements for an external wall or an overcladding system as applied to an external wall. On those two passages, let me just ask you a number of questions. First, is it your opinion that a reasonably competent architect is expected to be capable of interpreting and applying the guidance in ADB as far as it relates to an overcladding system?
Yes.
And you don't say, I think, and tell me if I'm wrong, you don't mean to say that when the linear route is adopted, in other words, compliance with each of paragraphs 12.6 to 12.9 of approved document B, a fire engineer, if appointed or consulted in any other way, is relieved from any obligations to provide advice and guidance on the linear route?
Absolutely not. If they're appointed, they're appointed.
Yeah. Would you agree that the external flame spread rating of a product may need to be verified by a fire engineer?
That's the information as given in an employer's, in a manufacturer's documentation.
Or a certificate?
Well, that's, forgive me, but verified by suggests that there would be some kind of a retesting of that. Should I interpret that to be that the fire consultant would explain that part of it, or you actually asked me whether they would retest it in any way? I'm sure you're not.
Well, there may be a debate about what verification it should involve, but from an architect's point of view, where an architect did consult a specialist fire consultant, would the reasonably competent architect, let me ask it openly, what would a reasonably competent architect expect the reasonably competent specialist fire consultant to do by way of satisfying themselves that a particular product had the relevant external flame spread rating?
I would expect the specialist fire consultant to examine the certificate provided, the BBA in this instance, and to ensure that that was clear and compliant with ADB2.
Yes. And do you think that a reasonably competent architect might be expected to seek advice from a specialist fire engineer if they were uncertain as to whether a particular product was of limited...
If they're uncertain, they must obtain certainty from somewhere, and that would be the place to go.
Thank you. In these paragraphs of your report, do you mean to say that the specialist fire engineer, in this case Exova, had no obligation to carry out compliance checks on stage reports or other design material produced by Studio E pre-tender in order to satisfy itself that the guidance in ADB had been adhered to?
Well, that suggests that I've said that. I certainly wouldn't wish that to be the interpretation.
No, thank you. That clarifies that. Now, in your report, I think it's right that you consider only the first route to compliance with the building regulations, which people in this inquiry have called the linear route.
Yes.
Is that right?
Yes, that is correct.
And I think you've measured Studio E's professional standards only against that route to compliance and no others.
That's correct.
Yes. And why is that? Can you just explain?
Two reasons. In the absence of any stated alternative route, that is the default position. Secondly, I remember that in their own technical review of their work, they stated that compliance had been achieved. I believe that's correct.
Just on the first of those answers, you say in the absence of any stated alternative. Stated where?
Well, with a submission to a building regs department, it's, the architect would set, or the documentation would set out the way in which the design had been developed.
I see. So you say that where they hadn't said that they'd pursued, for example, an 8414 full-scale test, the default is that they would have pursued, or
yes,
be taken to have pursued the linear route. And
before the break, I said that it would be unusual, for example, to undertake a full test. So these such a route would have to be made clear.
Yes, I see. Now, you've heard evidence from a number of witnesses, perhaps, saying that the building regulations and the associated guidance are not fit for purpose. And that's a general view. Just in general terms, do you agree with it?
Well, there's two different issues there, the building regulations and then the approved documents. If we restrict the building regulations conversation to the issue of overcladding and fire, I think they are abundantly clear. And I think insofar as they go, they are fit for purpose. The ADB documentation is much, ADB2 documentation is a much more substantial document, and it's pretty complex. And we've seen Dame Judith's report on this. I think there is more difficulty with that document.
Regardless of the degree of complexity or comprehensibility of ADB, on which I suppose opinions may reasonably differ, is it your opinion that Studio E failed to follow ADB or any other recognised route to compliance?
Yes.
And did that failure fall below the standard of the reasonably
Yes.
competent architect?
Sorry, I anticipated the conclusion of that, but yes.
Yes, thank you. Do you think that the decision as to which route to compliance with functional requirement B4 of the building regulations that the design should take is a decision for the architect?
Not solely, but the architect here was lead consultant and would have to garner opinion from anywhere that it might be relevant, but then ensure that a strategy was adopted and clearly understood.
Yes, perhaps by the word decision, I mean ultimate decision.
I think so, yes.
And what would your view be in respect of the proposal to overclad Grenfell Tower specifically? Was Studio E the ultimate decision maker in respect of what route to compliance should be taken?
Yes, they were driving the process.
Yes. And in your opinion, should that decision reasonably have been taken on the basis of a consultation with a fire safety engineer, given what Studio E did and didn't know and what experience they did and didn't have?
Yes, it follows from answers that I've given earlier. An architect has to assess their own ability, experience and competence, and in circumstances where they hadn't done a building of this type, then I think that they should ensure that they're receiving that advice from somewhere. In this instance, the fire engineers were appointed, so it would follow logically from that they should ensure that they have got the advice that they need to do their work properly, and to assure them that they're doing their work properly, they should receive that advice and confirmation from the fire consultant.
And would you expect the reasonably competent architect to have reached the decision about which route to compliance with the functional requirement in B4 before the tender process?
Yes.
Yes. Does that tell us that the reasonably competent architect wouldn't be relying on the input of a specialist subcontractor, specialist cladding subcontractor, to make a decision?
No, absolutely not. No, absolutely not.
No. Now, forgive me for this question, but were you aware, as at 2012 to 16, that there was a distinction between non-combustible materials, materials of limited combustibility, and combustible materials?
Yes.
And I've used the years 2012 to 2016. I think there are others who want me to ask that question on the basis of the period prior to June 2017 as well. I take it that the answer must be yes.
Yes.
And in practice, how would the reasonably competent architect go about discovering whether, for the purposes of the linear route to compliance that he had selected, a material was of limited combustibility within the meaning of ADB, and specifically paragraph 12.7?
Well, I think broad descriptions of materials may be contained in ADB be, but essentially it's going to be certificates provided by manufacturers of their product.
And we'll come back to that in some detail. But you say certificates. Could we then just turn to ADB itself? CLG, please, 500173. And I'd like to go to page 95.
Sorry, I apologise there. The word certificates is resting heavily on my mind. Manufacturers' literature and information would be certainly the first guide. In some areas, may well call for those 4 certificates to support that literature.
And would it be your experience that manufacturers would use the certificates as part of their literature? Yes. Can we then look at what is in front of us, which is paragraph 12.5 of ADB, and that says the external envelope of a building should not provide a medium for fire spread if it is likely to be a risk to health or safety. The use of combustible materials in the cladding system and extensive cavities may present such a risk in tall buildings.
Yes.
Do you agree that that provided a clear warning to the reader against the use of combustible materials in the cladding system? Yes. Was there anything unclear to the architectural profession, so far as you know, about what that was saying?
No, it's perfectly clear to me.
Do you accept or agree that a reasonably competent architect should take into consideration that warning in respect of combustible materials when considering the specification of such materials in an external wall structure?
No doubt whatsoever.
Right. And again, the overall functions or functional requirements of adequately resisting the spread of fire and whether the use of combustible materials would comply with that objective. Same question again.
Yes.
Yes. And do you consider that whichever route to compliance with the functional requirements of B4 is chosen, that a reasonably competent architect ought to have been aware of the dangers of using combustible materials within an overcladding structure?
Yes.
And does it follow from that that you are of the opinion that Studio E ought to have sought assurances from a fire safety engineer, if they couldn't get there themselves, as to the safety of these materials when used as part of the system as a whole?
There's an awful lot of materials and components go into that wall, but the broad answer to that is yes.
Yes. Could we turn to SEA 50169, please? This is Studio E's NBS specification. Now, the one I'm going to show you is actually dated the 30th of January 2014. In fact, the version that went to tenderers is dated the 28th of November 2014, but there's nothing that is materially different about this document. This is just the final version of it. My first question is, have you yourself ever compiled a specification using the NBS software similar to that used by Studio E when they came to compile this document?
No, I haven't myself. Earlier on, I've used predecessors to that and handwritten and drawn together specifications. That was early in my career, but no, I haven't.
Right. So you've done a specification, but not on the NBS software.
No, I've certainly written some substantial specifications.
Right. We'll leave aside
days when we used ink and a pen, I'm afraid.
Well, leave aside the software point. Just in principle, do you accept that a specifier using the NBS system, whether it's software or hardware, has basically got 3 options, either to compile a performance specification, a prescriptive specification, or a proprietary specification?
Yes. Yeah.
Yes. And each of those, breaking them down, a performance specification, am I right, is one where the desired outcome of the material is specified?
Correct.
And a prescriptive specification is one which provides the full details of the product type, the material, the workmanship, but doesn't specify the particular product to be used.
Correct.
And a proprietary specification, the third of these, is one which actually names the specific product to be used in order to achieve a particular outcome, whether it's aesthetic.
Yes, that's my understanding, yeah.
Yeah, aesthetic or functional outcome. Yeah. And is it right that, in your experience, a specification may well combine a number of these different approaches?
Yes. Yeah.
You're familiar, I'm assuming, with the NBS specification?
Yes.
Yes.
Yep.
Do you agree that, as regards the external facade of Grenfell Tower, which is part H92, the rain screen, within this NBS specification, Studio E's specification adopted for the most part a proprietary approach.
Yes, I think that's correct, yeah.
Yes. And that's, just to be clear for those listening, that is because it named specific products.
Yes.
Yes. And it also said that Studio E had latitude, or were giving latitude to tenderers to choose a similar or equal product.
Yes, and that's a core sort of cultural issue of design and build.
You say it's a sort of cultural issue of design and build. Can you just explain what you mean by that?
Well, the general idea is that contractors should be free to find equal and alternatives to ensure that they've got usually the most economic solution. Contractors frequently have their own supply chains. They're buying in bulk across many, many contracts, and they can use that muscle to drive prices down in favour of their particular company. So they may well have preferential routes to satisfying a specification, which would lead them to seek to use alternative equivalents.
Yeah. You say equal and alternatives in that answer, but also alternative equivalents. I want to get a better feel for what exactly you mean by equal or equivalent. Do you mean that the freedom given to a contractor is an economic one, but it doesn't extend to changing the functionality or performance of the primary choice?
Not without agreement.
Right. So within equal, or similar or equal, is it your opinion that that expression used in the industry denotes a different material but of the same performance and the same performance quality?
It might do. I'm thinking more frequently of a different product, but a different manufacturer, but achieving the same. But it might be a completely alternative material.
But achieving similar or equal what?
Outcomes in terms of a range of things. The function. A good example, I think, might be the zinc versus ACM. An appearance which is acceptable. That might relate to panel sizes, joint sizes, etc. And a visual appearance that is satisfactory, but also a performance in terms of, the effectiveness of keeping weather out, durability, a range of issues.
Fire safety?
Oh yes, of course. Yeah.
Yes. You say yes, of course, as if it was a given.
Well, it's given on everything that we do. Yes.
Right. So similar or equal, you interpret as similar or equal in terms of fire performance, as well as aesthetic appearance.
Yes, it would have to comply with the basic requirements that have been set out.
Yes. Now, am I right also that the starting point in a tender is the product actually contained in the specification as the primary choice?
Yes.
That's what you start. That's your linchpin.
Yes.
Yes. Am I right in thinking that Studio E could, as an alternative approach, have specified a set of operational requirements and then leave it to the tenderers to identify the materials that they would use in order to satisfy those requirements?
Yes.
And could a performance specification requiring fire safety, compliance with fire safety requirements in the building regulations, have been drafted as a means by which to achieve greater input from the design and build contractor in ensuring that the fire safety of whatever products we use was achieved?
Yes.
Yes.
Yeah.
Was it unreasonable for Studio E not to have taken that approach?
Well, they've got other issues to think about. There's planning consideration. The building has to achieve a approval under planning, and the planners are going to be very concerned about the appearance of material, and so it's not unusual. In fact, it's very sensible to get as many of those sort of issues dealt with as soon as possible. Time is always the killer here. You need to nail the design principles as early as possible. So I would suggest that it would be better to be as prescriptive as possible as early as possible.
I see. just following on from that, do you agree that under a design and build procurement method, as we have here, in the case of Grenfell Tower, if the architect uses a specification which specifies the precise products to be used, so proprietary, rather than specifying the desired outcome by reference to performance criteria, the architect assumes responsibility for making sure that the products are,
Yes.
in their contemplated use, compliant with the building regulations?
Unless they've stated otherwise, yes.
Compliant with the building regulations? Yes. And if Studio E didn't seek to satisfy itself that the materials being specified, even as alternatives, complied with the building regulations, then they fell below the standards of the reasonably
Yes,
competent architect?
correct.
Yes. Can we look at paragraph 2.10.24 of your report? That's at PHYR 5027, please, at page 53. And this is under the heading, some pros and cons in relation to design and build. And at paragraph 2.10.24, the second paragraph down, you say the second issue relates to process.
Yeah.
Under traditional procurement, the architect has a far greater control for selecting and specifying the building materials and components. Under design and build, the architect usually shows indicative arrangements, which may frequently be less developed at the tender stage. He may frequently be asked to obtain tenders on a variety of options, for example, cladding, as occurred at Grenfell Tower. Indeed, even after appointment, the successful builder may introduce major changes to the specification during design development and value engineering. Is what you're saying here, just to be clear, a generic feature of design and build contracts?
Yes.
And is it your opinion that whatever major changes are made to the specification by the contractor during design development and perhaps value engineering, a reasonably competent architect would regard his responsibility as confirming compliance of the materials which are specified with the building regulations?
Yes, I'm afraid this answer will be a little longer, if you'll permit me, but it, of course, depends on the point at which the project is put out to tender. It depends on whether the architect is novated and transfers responsibility. It effectively is retained, but essentially the answer is yes.
Yes. So unless he's specifically instructed, you say that the an architect's obligation to confirm compliance of the materials specified with the building regulations remains undiminished.
If the architect is retained, that is correct.
Yes. Could we look at RYD 3094357, please? This is the design and build contract, and it's the first page dated the 30th of October 2014. This is the executed version of the contract between the TMO and Ryden. And if we go to page 87 of that document, it's actually a pack of contract documents. We can see under project particulars A10 design that it stated that all design work completed to date RIBA stage E. Do you see that? This is the penultimate entry down. Design : all design work completed to date RIB stage E. So it's the pre-penultimate on the
consultant's novation. That's the one, isn't it?
just above that.
Oh, design. Oh, I see. Sorry, I beg your pardon.
It says design, all work completed to date, RIBA stage E.
I'm just reading it, yes.
Is included with this tender document. Yes. My question is, does that include technical design?
Well, there is technical design within stage E.
Yes.
So as far as it had gone, or should have gone under stage E, and also as far as it actually had gone, yes.
Yes. And is it right that regardless of when the contract is put, such as this, is put out to tender, the materials that go into the specification have to be checked for compliance?
The architect produces information, which in this case Artelia draw together, and issue, and that information has to be checked,
Yes.
correct?
I mean, put it another way, would a reasonably competent architect do his stage E work without ensuring that the materials or products which are specified up to that point are compliant with the building regulations?
The key qualification you've used is up to that point. That is correct.
Yes. And up to this point on this project, November 2013, which results in this document, would you have expected Studio E, as the reasonably competent architect, to have ensured that whatever products were specified or stipulated in the NBS specification were compliant with the building regulations?
Yes, they should have been compliant from the moment they were first introduced,
Yes.
and they should have been checked on the way through.
Yes, thank you. Now, if we go to your supplemental report at PHYS 602 at page 46, we can see paragraph 2.4.15. I asked you about technical design. Here at the top of the page, you give some more detail about what that is. And you say technical design usually prepared / provided by a consultant design team, drawings which give information that is adequate to describe the elements of construction in sufficient detail to establish fitness for purpose, buildability, and in principle compliance with building regulations. So it looks very much from what you say there that that tenderers, when they were considering the contract documents, would be entitled to expect that compliance of these materials which are specified in the employer's requirements within the building regulations. Sorry, start again. They were entitled to expect that there was compliance of the materials specified with the building regulations and that had been checked and confirmed.
Correct. I think this is one of 4 bullet points, actually. This is 3 of 4 bullet points. I think there's an earlier one, but
Well, let's turn the page
not.
back. Let's turn the page then back to page.
The answer
45.
is correct. You are correct.
Yes. Okay. Just to give it context so that everybody can see it. If we go back to page 45, you can see the first of the bullet points.
Yes, that's right. Sorry, it helps me orientate myself.
No, absolutely. And you are here examining technical design stage E. And you are explaining what is involved in that stage.
Yes, correct.
Yes. Okay, but I think the answer is yes. Would it have been, and we touched on this earlier, but just to confirm it when we're looking at this, would it have been usual for the tender documentation to have been discussed with building control before it was issued to the potential tenderers?
Not in its entirety, but aspects of it I would have expected the design team to have shared with building control, both in the form of meetings and in the form of submissions, information sent before the building regulations application is made, sent through, and comments passed back.
Would a design and build contractor be entitled to proceed on the basis that since an NBS specification like this was part of design that it had been taken to at least work stage E, that the materials or products specified in it were compliant with the building regulations?
That's a legal point, I think.
Let me put it differently then. Would a reasonably competent architect anticipate that a design and build contractor would regard themselves as entitled to proceed in that way?
Yes, I would certainly do that, but I'd like to again qualify that answer. In my experience, a competent design and build company, and I've worked with many, carries out a substantial review at the point of accepting the job. They've looked at it very carefully through the tender documents, and they've won the job, so it's sleeves rolled up, and let's have a really thorough check, because, guys, we're taking this lot on, so we need to be pretty sure that anything that's missing is identified, and let's have a good thorough check on what we got.
And following on from that, would it be your view that since the design and build are taking this lot on, as you put it,
I'm sorry, it's a
would
bit
be having
informal.
No, that's fine. Would be because it's clear. But would it be your view that the design and builder taking this lot on would have a really thorough check themselves that wouldn't absolve the architect from having done its previous check to satisfy itself that the materials and products it was specifying in the NBS specification were compliant with the building regulations?
If I may, the issue of checking is, I'm sure, going to come up a lot, and I think there's checking upon checking with this job, and I don't like too much checking. What I like is the correct process of analysis at the right time by the right people. The contractor, I don't think, is necessarily competent to carry out the check, although some contractors employ their own architects. I don't think we should assume that they carry out the check. What they should be doing is satisfying themselves that the work has been thoroughly checked. And that would take the form of, you guys are coming on board as our architects. What processes have you been through? Let's have a look at some of the issues that have been developed along the way. We have the following questions from the point at which we were preparing our tender. We're bringing them all to the table because we won the job.
I follow.
Here we go.
Yeah, thank you very much. So the answer to the question is that the reasonably competent architect would expect to be asked by the incoming design and build contractor, if they were competent, assuming they were competent, that architect had carried out sufficient checks itself to make sure that the materials specified in the specification were compliant with the building regulations.
That is correct, and it's checking, the competent architect who's doing the work needs to be checking their work at every single stage as they go through.
Thank you. Can we then look on at your supplemental report at page, I'm sorry, it's behind actually, 25. Go back to page 25 in the same document. And I'd like to look at paragraph 2.3.3. We looked at 2.3.2 earlier. 2.3.3, you say, it is also my opinion that any obligation on the part of the subcontractor to complete the design in accordance with the designated code of practice, see 12.14 of Studio E's opening statement, does not impose an obligation upon that subcontractor to undertake a checking role or to assume responsibility for any or all past work of the architect. Further, this most certainly does not exonerate the architect for any design failures in its own past work that are not picked up by the subcontractor. And then you also say, if we can just look at another part of this report at page 31, can we look at paragraph 2.3.25 on that page? You say, sixth line down there, there is no indication whatsoever in this, which is, I should tell you, H92, paragraph 210, that's what you're referring to, which you can see above on the page. But you say, there is no indication whatsoever in this that the design and build contractor or its subcontractor, respectively, Ryden or Harley, had either a responsibility to check the broad assumptions and the principles upon which Studio E's work had been based, or that Ryden and or Harley would be absolving Studio E of responsibility for the work that it had done in this connection. When you say absolve there, do you mean assume responsibility in place of Studio E?
Correct.
Right. And finally, can we look at page 54 in the same document? I'm so sorry, it's a different part of your report. It's PHYS 605 at page 54. It's also your supplemental report because it's a different section of it. PHYS 605, page 54. And let's look at paragraph 6.3.4. You say there, after some qualifications, these qualifications aside, I agree with Harley's implied suggestion at paragraph 20 that it was entitled to proceed on the basis that when compiling the NBS for the project, Studio E's work as provided under the employer's requirements was compliant with the requirements of the building regulations and the guidance contained within ADB 2. Now, I just want to be clear about what I've just put to you there. You're professing no expertise, are you, as a specialist cladding subcontractor?
No.
No. Can you just explain the basis on which you consider that you can express an opinion about what Harley themselves did was reasonable?
Having worked with subcontractors, a variety of disciplines, not because the principles are in many ways similar, not the same, across different aspects. But here we're talking about cladding. having worked with subcontractors through main contractors, I've gained an experience of the way they think and they work, and so it's based on that.
I see. So this is your opinion as an experienced and reasonably competent architect about what you, in that role, would expect Harley's, as the reasonably competent subcontractor, to do.
Yes, but may I qualify that a little?
Yes.
I've listened to, I wrote this before I heard evidence, and the evidence has come across a long period of time. I don't want to imply with this that a subcontractor has no responsibilities for their own work. And it's important here to remember that Harley had offered themselves through their own documentation as experts in overcladding buildings. And part of the decision, and we heard this from the evidence of Mr. Madison, I think, part of the decision to select Ryden and through Ryden Harleys was based on their past experience. And I think that can be taken into account by an architect.
Yes.
And I don't think a subcontractor can just say, well, we breezed up and we got no responsibility even to comment on anything. We'll take it all blind. You would expect them to have some substantial knowledge which they would inform their work with, and they would raise questions if they thought something was fundamentally wrong.
Yeah, thank you. Can I then turn to a different topic, which is the ACM material? I want to ask you some questions about the compliance of and the selection of Rainobond PE55 aluminium composite panels, which were the rain screen material used at Grenfell. Would you expect a reasonably competent architect to be aware, first, that ACM panels were manufactured at the time with different cores, a PE core and an FR core?
No.
No. Is that, therefore, particular specific knowledge that an architect you would expect would obtain as part of their preparation for the initial design of a rain screen cladding system, if appointed on a project such as Grenfell Tower?
Yes.
Were you yourself aware, during the period 2012 to 16, that ACM panels came with a PE and an FR core?
No.
Would you expect a reasonably competent architect to be aware that of the fire performance properties of ACM panels in general, aluminium composite panels in general?
Yes. Yeah.
Yes. Could we look at your supplemental report, please, at PHYS 602? And I'd like to look at page 52. And let's look together at paragraph 2.5.10 on that page, at the top of the page there. You say, it would have been impractical, and indeed it was not part of my instructions, for me to investigate and provide contemporaneous examples of the approach of a reasonable body of the profession for this kind of work, as has been suggested at paragraph 8.16 of Studio E's opening statement. On that basis, I simply do not know in any detail what had, at the time of the Grenfell fire, been done elsewhere, although I am aware that widespread problems have been reported, as suggested at paragraph A1.4 of the RIBA Expert Advisory Group on Fire Safety's report, 19th of October 2017, submitted to Dame Judith Hackett during her review. How similar the various pieces of design work relating to any such problems are to the work that Studio E carried out for Grenfell Tower, I cannot know. As previously stated, even if I was to be presented with such a body of evidence, for example, evidence that many other overcladding projects to existing residential tower blocks in the UK revealed widespread and basic failures to meet the requirements of the building regulations, such as are evidence within the work of Studio E at Grenfell Tower, I would remain equally critical of Studio E. Now, I read that to you in full. There's some questions that follow from that. If architects in the UK were routinely specifying ACM panels with a PE core prior to June 2017, should this not weigh in your analysis of the steps that a reasonably competent architect ought to take when considering the compliance and specification of those products?
I think so, but this paragraph was intended to comment on the worker studio area across the entire overcladding. It wasn't specific to just ACM.
No, I understand that. But so I think the answer is you think so, and I appreciate that this paragraph is a more general paragraph than just on the ACM, but specifically in relation to the ACM, would the fact that if it were the case, architects in the UK were routinely specifying ACM panels with a PE core, would that fact not weigh in your analysis of the steps that a reasonably competent architect ought to take when considering whether or not those panels complied?
Yes, architects were specifying, and yes, I agree, yeah.
Yes. Does the routine specification of such products in the industry, if that was the case, indicate, or would it indicate, a common industry practice?
Well, ACM has been specified extensively. It is a commonly used material.
Yes.
A commonly used, it's not a material. ACM, that's why Dr. Lane calls it ACP, which I agree with. It's aluminium, a core, and aluminium as a composite. So it's not a material, but it's a very commonly used product. Product is the word.
Absolutely, understand that. Just looking at the industry practice, if the industry practice was that ACP, as you would prefer to call it, was being commonly prescribed, would that fact bear on the standard by which a reasonably competent architect should be judged when an architect prescribes it?
Yes.
Yes. And how much weight would you think that should be given when judging an architect's performance?
Well, I think we're comfortable to specify products which are regularly used. One gains the increasing comfort in that way. But there is still the obligation to check that that product meets the requirements of ADB2, and it's specific within that document as to what the performance should be. So I think a degree of comfort can be obtained or enjoyed by the architect, but at the end of the day, they've got to be satisfied that the particular manufacturing, particular product is okay.
Thank you. Now, if we go back to SEA 50169, please, back to the NBS specification, I'd like to go with you to page 69. And on this page, and this is part of H92, rain screen cladding, halfway down the page, under the rubric Design / Performance Requirements, you see it says CWCT standard for systemized building envelopes. You see that there?
Yes.
Now, you'll have heard the evidence of, or seen the transcript of the evidence of Mr. Reck, R-E-K,
yes,
an employee of Studio E at the time. And his evidence was that the CWCT standard is offered for inclusion into section H92 of an NBS specification. And then you change the question mark to a green tick if you want to include reference to the specification. That's how you go about it. And just for our purposes in the transcript, that's at day 12, page 37, line 20 onwards. That was the evidence he gave. Do you consider, in your opinion, that Studio E should have been familiar with the contents of the CWCT standard before it chose to specify that standard expressly within the body of H92 within the specification?
Somebody in the firm needed to be comfortable that they understood that. I don't see how an architect can responsibly include qualifications or parts of a specification without understanding them.
Would you say that Studio E was under a professional obligation to make sure that the products that it was specifying, whether as the primary product or the similar or equal alternatives, fell within and satisfy the CWCT standard that the architect was specifying here?
I think the bottom line is, does it satisfy ADB 2? But I think that this is an important document. It's by the federation that lead the collective, the subcontractors involved in this kind of work. And so I would have thought that it was good guidance to use, yes.
Now, Mr. Soanes said in his oral evidence, and for our reference purposes, this is day 7, page 164, line 18 of the transcript, that he hadn't read this standard at the time of working on the refurbishment. In your opinion, did that failure, or that non-happening, fall below the standards of a reasonably competent architect?
Well, if you would forgive me, I don't want to comment in that respect on Mr. Soanes and his particular duties, because I'm not clear about that at this point in time. But the firm of Studio E, I think, should have had a technical competence amongst its team to understand this document, and somebody in that team should have certainly familiarised themselves with the general principles of it.
Well, okay, taking Mr. Soanes in particular, he hadn't read the standard, as he said. And if nobody else in his team had read the standard, would that mean that Mr. Soanes had fallen below the standards of the reasonably competent architect team leader leading a team of designers?
Well, if he's the team leader, he should have made sure that the work was properly understood, yeah.
And as a firm, let me ask that question again. If nobody in Studio E had read the standard it was specifying in the NBS specification, would that failure fall below the standards of a reasonably competent architect? Yes. And it would follow from that that it was not the action of a reasonably competent architect. Sorry, let me start that question again. Do you accept that Studio E fell below the standards of a reasonably competent architect in not ensuring that the product specified complied with the standards expressly referred to?
This question is relating solely to the ACP?
To the ACP, yes, just in relation to that and the CWCT standard stipulated.
Well, for me, the bottom line is ensuring that the requirements set out in ADB2 are met by the product. And I think that was a separate and a pretty clear affirmative.
Yes, but here we've got a specific reference to CWCT standard for systemised building envelopes. And if that standard, as we shall see in a moment, contains guidance or illustration, advice, market information, industry information, technical information about rain screen cladding, then a reasonably competent architect stipulating this specific standard in its own specification should have read and understood that standard.
I think so. I'll no doubt find which particular issue you're going to be questioning me further on, but yes. Okay.
Well, is the answer yes, first of all?
Yes.
In general terms, yes, thank you. Then let's look at the standard. It's CWCT 5046, please. 5046 at page 11. I just want to go straight into it and go to paragraph 6.3 in the second paragraph from the bottom. And it says in italics, and this is under the heading fire resistance, it says aluminium envelope systems do not normally have significant resistance to fire. Most unmodified aluminium building envelopes will provide only 10 to 20 minutes stability and integrity resistance and negligible insulation resistance. And then if you go to paragraph 6.2, higher up the page, third paragraph down, it says, the building envelope shall not be required to provide fire resistance unless a performance is stated by the specifier. You see that?
Yes.
And then the third paragraph down, fourth paragraph down, the building envelope shall not be composed of materials which readily support combustion, add significantly to the fire load, and or give off toxic fumes. Are those things that I've shown you, those three things on that page, things that a reasonably competent architect briefed to design an overclad of a high-rise building should know?
Well, I think they should know them, but I haven't seen anything here that says that an ACP product should not be used. It's the comments are more general, I think.
I'm not asking you whether the CWCT guidance advised not using ACP or ACM products. I'm not suggesting that to you. All I'm asking you is whether those 3 items I've selected from this page are things that a reasonably competent architect who is briefed to design an overclad of a high-rise building ought to know.
Yes.
Yes. And do you think that that is especially the case in the case of an architect who actually chooses to stipulate the application of this very standard in his own specification?
Yes, but if I take that 4th paragraph down, the building envelope shall not be composed of materials which readily support combustion, add significantly to the fire load, and or give off toxic fumes. Well, if we look at the profession generally, and all of the professions involved, I'm talking about facade engineers, a range of others in modern buildings of this type, ACP has been extensively, widely used over a long period of time across a wide range of countries. And you could say that all of us should have been far more focused on this line here. So I do not want to suddenly turn on Studio E and say that the weight of that 4th paragraph should rest entirely on their shoulders. The industry was generally using those products.
Yes.
While we've got this open, just help me. In your understanding, and I'm only asking you for your understanding of this at the moment, does ACP readily support combustion?
Well, at the time, I did not think.
Does it readily support combustion, is my question.
No.
Yeah, all right. I think we might all know the answer to that, but I'd just like to...
I think it's difficult to get it to burn, but once it's burning, it burns with ferocity.
And does it add significantly to the fire load?
Once it's burning, yes.
And the question which I think you would wish to answer, was that something which architects generally were aware of at the time?
I don't think we were.
Right, yes, thank you.
Actually, we weren't, is the answer. We weren't. There's no think we were not.
Right, thank you.
Does the fact that these 4 paragraphs, as I've shown you, within this very specification, which expressly forms part of the NBS specification, not have acted, or should they have acted, as a prompt or an alarm bell to Studio E, just to make sure that the building envelope that it was proceeding to design didn't readily support combustion, didn't add significantly to the fire load, and didn't give off toxic fumes?
We're on the entire overcladding, or focus just on the
ACP, let's focus on the ACP.
Yes.
I appreciate the point about the building envelope as a whole, but just focusing on the ACP at the moment.
I think an architect, yes, that is correct. I think that should make us alert.
Yes, thank you. Do you agree that an architect specifying a specification for an overcladding facade which included reference to this standard, the CWCT standard for building envelopes, in 2013 should have been aware also of the subsequently published CWCT Technical Note 73 of March 2011? I say subsequently because this document is an earlier document.
Yes, yeah.
Yes. Can we look at that? That's at CWCT 5019, please. And at page 1 in the left-hand side, on the left-hand side, under the heading Introduction, and this is the penultimate paragraph, it says, rain screen walls are additionally required to limit the spread of fire in the rain screen cavity. Do you think that information, or that requirement, or that statement of the requirement, I should say, in addition to that set out in the standard we've just looked at, ought to have caused the reasonably competent architect to consider whether an FR cord panel would be required?
No, and the reason for that is that I don't think that I may be going back on evidence I've just given, in which case I apologise, but the difference between fire retardant and cause was not as clearly understood at the time as it should have been, and it hasn't been since, actually. There's going to have to be a root and branch review of all of this across the entire industry and across all of the professions involved. I came across the difference by accident. So I suppose you could say that faced with all these documents and wading into them in the most immense detail, maybe it should have become apparent. I learned about it, the difference, by accident, independent actually of this inquiry, but by accident. But the broader point, rain screen walls are additionally required to limit the spread of fire in the rain screen cavity. The principle of that we should all know and understand fully.
Thank you for that. And that then leads me to this. Would this statement in this document, Technical Note 73, coming from the CWCT, have made the reasonably competent architect think that they needed to look for products which were going into the rain screen walls to ensure that whatever was available on the market resisted the spread of fire or limited the spread of fire as much as possible, and therefore actually go out actively and look for what was available, namely FR products?
It's not an answer which is particularly helpful, but it's a sort of yes and no answer. The problem is we don't know what to look for. We take in so much on trust. We've got so much going into a building, and it's not particularly to do with limits of time, although time is crushingly tight. It's to do with not knowing what to look for. And I think it's fair to say that the designing part of our industry, I'm making that separation from the manufacturing part, so I'll actually include contractors in this as well. None of us had any idea that there were such dangerous components being incorporated into a composite panel.
Would the fact that this statement appears in a technical guidance note such as this not have prompted the reasonably competent architect, at the very least, to spell out in the NBS specification that whatever product was being used or chosen in the end, the rain screen walls were required to limit the spread of fire in the rain screen cavity, so that the contractor would know that whatever product was ultimately chosen, it would comply at least with that?
I don't think so. I think that the architect would take that and ensure that in her own work they were not breaching that. And I think many of us would have blindly stumbled into the same problem.
Right. And to know what to look for, you would have to look at the manufacturer's literature, wouldn't you, on a case-by-case basis, before you put...
That's certainly a very good starting point.
Well, before you put the material into your MBS specification.
Yes, it's the starting point.
Yes. Sorry, to repeat the question. Before you specified the particular products, whether it's for the rain screen or the insulation or any other element of the exterior wall construction, you would look at the manufacturer's literature to make sure, as much as possible, that it complied with the CWCT guidance and this technical note.
Yes, sir. Yes.
And of course the approved documents.
Yes.
Yes. Now, you address the fire classification of the Proteus, the zinc Proteus cladding panels, and the three alternatives included as alternatives in the NBS specification in your report. Let's look at that. That's PHYR 5029, page 50. and you say at paragraph 4.3.27, Clause 11 in Studio E's full NBS H92 employers requirement document of the 30th of January 2014, which was what we're looking at, or were looking at, included a provision for tenderers to provide a cost comparison for alternative cladding systems from the list exhibited below: Rainabond, Alucobond, Zinc. I am critical of this listing as it refers in one instance to a product name, Rainabond, in a second to a manufacturer, Alucobond, and in the third to a material. It seems that the references are to, and then you set them out, Alcoa Architectural Products, Rainabond, Alucobond, Spectra, VM Zinc, Quartz Zinc, and you say what those are. And then if we go to paragraph 4.3.29 on page 53 of this document, this report, you have there, and I'll just show this to you, you have there after the extract from the BBA certificate for the Rainabond, you say assessment at paragraph 6.1, a standard non-fire retardant sample was certified as compliant with European Standard Class B as set out in ADB2 diagram 40. Then if we look at paragraph 4.3.30 at page 54, you deal here with the Alucobond Spectra, and you say that that was tested to Class D under EN 13501, but tested to Class 0 in the UK. Just on that, as we can see, just pausing there, what does that tell us about the reliability of the stated equivalences between the Euro classes and the UK national classes?
Well, I think the Euro class is more specific in the way it measures performance than the British one.
How can something be Class D Euro but Class 0 UK? Do you know?
Well, Class 0, Class O, as is commonly referred to, but Class 0 as well, is a measure of a spread of flame across a surface. And the other classifications are a measure of the performance in terms of S and D being smoke emission and droplets as the material changes form from solid to liquid. And it's a measure of the rate of formation of droplets and the rate of formation of smoke. Now, beyond that, we're into a science which I don't have the competence to deal with, but that's the gist of the story.
Are you surprised to see a product, Alucobond Spectra, obtaining both an EU Class D, but at the same time a UK Class 0, or English Class 0?
I certainly am now. It begs many, many questions about the way we've all been operating. At the time, well, you'll no doubt go on to ask me about that.
Yeah.
So that's the answer.
All right, well, that's helpful. Can we go to paragraph 4.3.31, please, on page 55, where we see the VM zinc. And that says that achieves a B, BS1D0, according to the European Fire Resistance Standard EN 13501. And you say underneath that at 4.3.31 assessment, this manufacturer's classification confirms compliance with European Standard B, Class B as set out in ADB 2 diagram 40. And then at paragraph 4.3.32, you can see just below that on the page, the KME Architectural Solutions Proteus HR, which has Class 0 as classified by the building regulations. And it also says any specified fire breaks would be installed by a Proteus-approved contractor. A non-standard A2 system is also available. And you say in your assessment that the manufacturer's classification confirms compliance with ADB2 diagram 40 and with the Class 0 national standard. Now, say for the Rainabond product, are these classifications I've shown you taken from material which were on the relevant products' websites? When
yes, I think that was the source, yeah.
What steps, if any, did you take to ensure that the classifications were accurate as at the date of the NBS specification? So, for present purposes, you can take November 2013 or January 2014.
I don't know the answer to that, I'm afraid.
Well, did you take any steps to ensure that the classifications were accurate as at the date of the NBS specification?
Yes, that particular piece of research was done from somebody in my team. I assume that that would have been relevant at the time because that's the entire basis on which we were working across the board. But I personally didn't check that.
Very good. Can we then look at your report at PHYR 5029, please, at page 35? I want to ask you about paragraph 4.2.44 of your report, and I'll read this to you in full because it's technical. You say, finally, I note that paragraph 12.7 of ADB2 refers to filler material amongst the components and substances that must be of limited combustibility, where and when used in the external wall construction. Poor drafting has this paragraph under the heading external surfaces when it would clearly be better placed under the previous heading of external wall construction. That point aside, it is my view that the term filler material in this sense relates to a product or material such as mineral wool or PIR insulation, that is, something consisting of the same material, or at least largely the same material, throughout its makeup. I do not think that the authors of ADB2 intended the term filler or filler material to mean any part of a composite material, for example, aluminium composite panel, that is factory manufactured and delivered to site as a finished product. Rather, it is something either solid, for example, polystyrene, granular, for example, sand, or fluid, for example, mastic, that is put into, squeezed into, or poured into a host environment. It will be for the inquiry to determine the meaning of filler material in the context of paragraph 12.7 of ADB2, but I can affirm with confidence that as an architect I would never have interpreted the polyethylene core of an ACP panel to be a filler material in the sense of the term as used in ADB2. That is a material or component in its own right. Therefore, I would have looked in terms of considering the BBA test certificate in relation to the performance of the Renault Bond ACP panel only at the rating given to the product as a whole. I would not have made any inquiry of the elements of the product. Now, in coming to that opinion, did you consider paragraph 13 of Appendix A to ADB?
Can you refresh my memory?
Yes, I'm looking at you. I thought I probably ought to do that.
I rather regret I wrote such long paragraphs, actually.
But it was very helpful. But let's look at it. CLG 50173, please. Page 22. And if we look at, page 122. Sorry, page 122. And my fault, I've given you the wrong reference. Page 122. And if we look there, we can see paragraph 13. Now, I'd like to read this to you in full. That's slightly shorter than your paragraph. The highest national product performance classification for lining materials is class 0. This is achieved if a material or the surface of a composite product is either A, composed throughout of materials of limited combustibility, or B, a class 1 material which has a fire propagation index I of not more than 12 and a sub-index I 1 of not more than 6. Note, class 0 is not a classification intended in any British standard test. Now, sorry.
May I ask, could you just go back to the title of this whole section?
Yes. It is at either page 120 or page 121. And let's start with page 121 to see if I'm right about that. Well, I am, at least to this extent. Material, this is under internal linings.
Yes.
Yes. Is that what you were after?
Yes.
Yes. And what does that tell us?
This is a good example of the kind of confusion that does exist within this document ADB2, which I would suggest, I don't suggest, I'm absolutely clear, should be user-friendly. And it is not when information which may be key is buried in the document under the wrong headings.
Now, what you've just told us, is that a view you've come to during the course of your instruction for this inquiry and writing your reports? Or is that a view that you held in the period 2012 to 2016?
I grew up with the London Building Acts and constructional bylaws, and it was a different world of greater precision. I have never been the greatest fan of the approved document arrangement, but having said that, my criticism is to the drafting of it as opposed to the principle of the guidance that it gives. And I don't think the drafting, there are many, many examples where the drafting is not good. I did have a concern around the ADB documents before, but certainly my work on this, for this inquiry has, and I'm very sorry to say this, it's taken me through this document in the greatest of detail, and I have been somewhere between disappointed and appalled at times by some of the confusions.
Right. Let me refocus my question a bit more tightly. Is the view that you expressed about lack of clarity a specific view about the lack of clarity about this part, paragraph 13 of Appendix 1 of ADB?
No, there are other parts of the document which...
Okay. Now, does what I've just shown you, paragraph 13, affect your view as expressed about filler in paragraph 4.2.44 of your report that I read to you in full?
No, I would not have looked at the filler. I would not have sought evidence about the performance of the filler, the polyethylene, within the ACP panel. I would have taken the test certification at bold face value.
Test certification for the rain screen?
Yeah, well, I'm thinking of the Rayner bond in that respect.
Rayner bond. Mm. Yes, indeed. And the reason I'm asking you the question about your report and the passage I read you is because of the sentence in paragraph 13 that says this, which is class 0, is achieved if a material or the surface of a composite product is either composed throughout of materials of limited combustibility or a class 1 material, etc. And I'm just asking you whether your view about the polyethylene core not being a filler is affected in any way by class 0 being achieved by a material being composed throughout of materials of limited combustibility, or the surface of a composite product being composed throughout of materials of limited combustibility. Or is there no parallel at all?
Now or then?
I'm asking for your understanding and your clarification of your opinion.
Well, now it's clear to me that class 0, and I knew this at the time, but I hadn't considered it carefully enough. But it's clear to me that class 0 is the surface spread of flame. I always knew that, but I had not used that knowledge that I had as a basis for me interrogating the matter further. And it's very... I don't want to defend myself in this respect, but I'd like to say, when we talk about the rain screen cladding and a thin aluminium composite panel, it's easy to take that as the surface of the wall or the surface of the building. I didn't read that to be the aluminium. I've got 3 parts. I've got the aluminium internal part. I've got the composite, I think that was 0.5 of a millimeter. I've got 1.5, maybe it's 2.5 millimeters of polyethylene, and I've got an aluminium outer face. I considered the whole of that to be the external surface of the wall. I didn't consider the outer face of the aluminium composite panel to be in its own right and separately the surface of the whole wall. And that would lead, I would not therefore have interrogated the core of it at all.
And therefore, that takes me to this question. What, in your opinion, is the purpose of the core of the panel? You said it's not filler, in the way of understanding per 12.7. Therefore, what was it?
I know exactly what it was there for. It's the problem with metal cladding systems is that they tend to, we use the term oil can. And so when you're looking at the key with hanging a cladding system, it's glass or metal, is to get it to hang in a single plane. If that's done, reflections off it should be pretty regular. If you have panels which are not hung, then you don't get that. But if you have individual panels which themselves are not stable, they can twist and produce effect almost like an oil can. That can be very, very visually distracting, unacceptable. So the role of the polyethylene is to produce stability to the aluminium panel to ensure that it lies in or hangs in a perfectly straight plane.
Yes,
that's why it's there.
Right. Now, can we?
Sorry if that answer was a little long. But
no, that's. Can we then go back to the heading?
Before we go away from 13A, and you've explained how you would have looked at if an ACM panel, the distinction between the panel as a whole and the surface of the panel being the aluminium.
Yes.
It is surely a composite product, isn't it, the ACM panel?
Yes.
And therefore, you would perhaps ask yourself whether it is composed throughout of materials of limited combustibility.
I think that I should have. I think all of us who have specified that without doing so can be criticised. I wouldn't want to focus undue criticism on Studio E in this respect. It's a universal problem, I think.
So would your view be that Studio E were at fault in not asking themselves that question in common with a lot of other?
Oh yeah, that would be the case. Yes,
Yeah, all right.
but that not in isolation.
No, thank you.
Mr. Chairman, that's probably a convenient
I
moment.
interrupted your question.
Well, I had a question. You've sort of asked it. I'm afraid, but there's one more question I could fit in. I think in the minute before 1 o'clock. You were interested in the title to this part of Appendix 1, or Appendix A, I should say, and that was linings. If we can go back a page to page 121. And that says internal linings. What's the relevance of that to paragraph 13 and class 0 generally?
Well, if it's internal linings, I wouldn't expect to be looking in here in relation to the external cladding. Very simple.
And why would class 0 be relevant to internal linings?
Well, again, we've got problems of fire with partitions. We've sat amongst partitions here. It's of concern to know what the linings, how the linings will perform.
Yes.
Yeah.
Yes. Yes. Thank you.
I have one. Can I make one further comment on that? Or maybe you're going to take me to diagram 40 after the break.
May well do.
Okay, then I'll save it for then. I'll save it for then.
All right.
All right. Is that a good moment, Mr. Millett?
It is, Mr. Chairman. Yes. Thank you.
Thank you very much.
Well, Mr. Hyet, it's time for us all to have some lunch. So we'll break now and come back at 2 o'clock, please.
Thank you.
Again, no talking about your evidence.
I will not.
Go away. No, thank you very much. Thank you very much. 2 o'clock, please.
Very good. Thank you.